Hey, what's going on, everyone? King here, back with another video. So in this video, I wanted to talk about the topic I covered before is, one, what is heir property and who are heirs to property? Again, I covered this topic or topics several times in other videos dealing with heir property as well as my experiences. But I want to watch this video. I think it's a good video that explains it and then get my thoughts on it. So without further ado, let's get into the video.
Heirs property is property that has been passed down through generations. As a result, has a fractured title and does not have clear title. And heirs property comes about either through someone dying without a will and the land or the home being left to the family members, and there being several children and a spouse, and then when those children pass away, then it's passed down to the next set of children, and it can go on for several generations. It can be passed down through not having a will. It can also be created through a will that leaves the property to, say, 10 children, and then those children end up leaving it to their children, etc. Oftentimes what happens, and what has happened in the state of Georgia, is that a lot of people during hard economic times left the state of Georgia looking for better economies elsewhere, and so you can end up with several generations down the line, you can end up with property that is owned by family members who actually don't know each other. And you can have one family member who's stayed on the property and worked it, if it's a farm, or lived in it and taken care of the house and paid property taxes. And then you can have family members who are second and third cousins who live elsewhere in the U.S. that have actually never even seen the property, but are part owners of the property through their heir status.
Some of the issues I see with heirs property include getting everybody in the family to agree on what to do with the property. Some of the family members may feel like they have more of a say because they may have more of a connection to the property than others who may have moved away and lived most of their lives away from the family property.
The land don't have to be divided. That for one of the heirs to come in and sell their part of the property.
Yeah,
I didn't know that.
We got knowledge of that today.
Yeah, I got knowledge of that. I didn't know that. I thought before they could sell a part of their property that the land had to be divided.
Other problems might be where any one of the owners of heirs property could sell their interest in the property and then sell their interest to someone who's outside of the family, and that person can come in at any time and assert their right to have the property partitioned. And if the property can't be physically partitioned, which means that it can't be physically divided between all the heirs, then the court might force a sale of the property so that everyone can at least get their share of the funds from the sale of the property. There are other issues where you might want to apply for a second mortgage on the property or refinance the property. That would be difficult to do with multiple heirs. Some banks or some institutions might allow you to get a signature from all the heirs to say that we agree to have this done, but others would say we want to have one or two people that we can count on to be responsible for this loan instead of having all these heirs on it. So they would want you to have a more consolidated title to the property. Okay, there's multiple ways to handle heirs property. One situation might be where you would actually consolidate all of the interest in the property into one person, and that would require all of the other family members to quit claim their interest to the person who is going to have title of the property. So that's one thing you can do, to consolidate all of the interest into one person. Another option might be a trust, where each of the family members put their interest in the property into a trust and to the name of a trustee who would then manage the property on behalf and for the benefit of the family members. And another option could be a tenancy in common agreement. When you have owners of heirs property, under the law they're called tenants and or co-tenants, where each of them have a right to full use and benefit of the property, but then they also share that right with other family members. You could create a tenancy in common agreement, which is an agreement between all of the heirs to say, this is what we want to happen to the property and under what circumstances. This is how the property is going to be managed. This is who is responsible for paying the debts on the property, for paying the taxes. This is who's responsible for managing the business operations that take place on the property. So that's another option. Basically, what you would want to do is either have the title into one or a few people's names, or you would want to have some kind of agreement, whether it's through the tenancy in common, the LLC, or the trust, some kind of agreement with that all of the heirs agree to, that determines what will happen to the property. If you want everybody to continue to have an interest in the property, create an LLC, which is a limited liability company, and basically it's a business. And you would have all of the heirs transfer their interest in the property to the business, and so the business would then own the property. And each of the heirs would have a say in what happens to the property as owners of the business, and they might, if there are any profits to be divvied up, then they would get a share of the profits. And also they will also have to contribute to any losses that the business faces. If there's any debts that are taken out and the business is not able to pay the debt, the family members might be responsible for their percentage of that debt.
We're very fortunate to have parents, grandparents who are or were landowners. Through them owning land and passing it on, it's 11 of us, and so we said that we wanted to keep the land in the family. So that's when we incorporated. We formed a corporation, and we did it through the state of Georgia. What we do in terms of making it managed for the 11 children, we have to pay property tax on all of the land. So we are accountable at the end of the year, and we divide the taxes up in Harris County and Talbot County, and we divide it by 11. And that's how we manage to keep the land going with the property taxes. We try to, as a corporation, be there to meet family needs. Everybody is important, and everybody has a say. And that's what we have to respect. Respect the family dynamics, and you'll be able to, you should be able to make it work. If you look at your parents and you see how hard they worked to get what they had. So we were very fortunate to have legal advisors. And that's the final piece.
In 2000, my father became ill and died suddenly. I went on his word that he had a legal will. What I found out after my father's death was he started a number of wills. None of them were complete. None of them were signed. So my father died without a will. I had 3 siblings and my father, so there were just the 5 of us. There was just no discussing it with him. He had control of it, and he did as he pleased with it. So after his death, I'm stuck, basically. I'm the only person that has any interest that is gainfully employed. But definitely from the year 2000, I've paid all of the upkeep and property taxes and everything since that time. At this point, I'm not sure how it's going to be resolved. I'm kind of like out there on an island by myself, and the people who should be, working with me to resolve these issues is like they're just happy because I have somewhere to stay, and that's basically it. But my advice to anyone is to be very persistent. When there is property, family property involved, that it takes persistence, and it's not you may get labeled, where they just want to know, what they're going to get and make, that kind of stuff. And that's not what it's all about, because when you get caught in the situation that I'm in, and really, no support from the people who are directly to benefit from the property, It makes it very difficult.
Wow, I know there's a lot to unpack there. In the this video, and the people talking in there, this was more so about the law situation in Georgia, the state of Georgia, but and here in South Carolina, it's pretty much the same thing. Laws may be a little bit different than how they, I said they as in the lawyers or the county or the judges. The state deals with heir property and people that are owners of heir property, but it's pretty much the same in essence as far as terminology. We talked about tenants in common, giving recognitions of creating a trust or LLC, or the misconceptions about heirs property. It's all in the same. And really, I wish I came up on this video, 6-7 years ago and showing it to my family. But I said before that education is important, information knowledge is important. It's key to everything. It's power. So when you know more, right, do better. In essence of when it comes to taking care of property, taking care of things, handling businesses. And the way they end, she really touched on it, is like, persistence. Trying to bring about that family dynamic, keep everybody together, make sure everybody's sharing their ideas, giving their input, and having that respect. It's something that I'm experiencing and trying to resolve the legal issues surrounding heir property and dealing with family for the last, again, I got involved in 2016, so the last 6-7 years now, dealing with family and being a target, being blamed for everything going on. But I want to touch on, again, the topic of this video is what is heir property? What is heir property? So, I'm sent for heirs property. Here's a pamphlet, I've shown this pamphlet before, but it's defined as heir property. Is defined as heirs property is a significant issue in South Carolina, especially in the coastal communities, with an increase in commercial and development interests. Heirs property is a prime target, and many heirs property owners have lost their land for lack of clear title or timely tax payments. Most heirs property in the Low Country is land that was acquired by African Americans after emancipation. So mostly the ex-slaves or the free slaves acquiring land. Much of this land has been passed down through generations without a will, so that the land is owned in common by most of the heirs. This unstable form of ownership puts the land at higher risk of loss because any heir can sell his or her percentage of ownership to another who can force a sale of the entire property in court. Additionally, many rural landowners in South Carolina have been unable to access the knowledge and services that would help them realize the economic value of ownership and ownership. So again, this is how they categorize heirs property, categorize or define what is heirs property. There's other definitions out there. You'll find on the internet. We covered in the beginning about what is heirs property. You talk about somewhat who are the heirs. Well, I want to touch on it more here because this heirs property does a good job of breaking it down and explaining it. You can go to the website. I'll leave the website link in the description below where you can find out more information about it. But so, who is the legal heir, or who is heir to property? A legally adopted child has the same legal rights as a child born to parents. A final adoption decree, court order issued by court is proof of adoption. So we're talking about basically children, right? So children of the original owners of the property, or a original owner of property, whether they're adopted or by birth. So raised children who were never legally adopted do not inherit unless the deceased left them an interest in the property in a written will. Simply using the deceased last name does not entitle you to inherit as an heir of the estate. Under current South Carolina law, children born out of wedlock are known as illegitimate or are considered legal heirs and they are able to inherit from a mother or father who died without leaving a will. If you're claiming interest in the land as an illegitimate child, you may be required to prove paternity to establish your claim. Right? So how do you establish in the property? I establish proof that you're heir to property, right? And it goes on further here, says that supporting documents such as death certificates, obituaries, death notices, and/or family records are extremely important without keeping. I will include into there, just talk about it, but birth certificates, right? Marriage licenses, those are important too. I talked about this in my other videos. Having these records, keeping records, do your research, and go to familysearch.org, which is free, free website that I use. I have an account on, and I was able to do a lot of research on my family, put down records that otherwise we would not have. Just reports, death certificates, birth certificates, marriage licenses. Yeah, I can pull all that stuff down and keep those records. So yeah, I just want to touch on this and give my thoughts on the matter. I think it was a good video to start to explain to people what is heir property and who are heirs, and what are some of the risks associated with heirs property, and how to deal with the not only family but the heirs property, the legal issues that is. Because you don't have to sell the land. People can partition it, divide amongst the other heirs, but it doesn't have to be sold. And if there is any issue in resolving heirs property, you can acquire a title. There's people that are living on the property and think that they have more rights to the property for whatever reason. You as an individual, heir or your family, have the right to bring forth a quatile action. This talks about that individual has a right to, I say individual, I mean heir, right? Individual heir, a person who owns interest property, will have the right to bring forth a action to sell the property. Well, they have the right to the right to bring forth a legal action to acquire a title. Basically, to preserve property, or just basically determine, hey, who are the legal heirs to this property? Who has rights to this property? Right? Who has rights to build this land, to utilize the land, to profit from the land? Because like I said, there's laws on the books to preserve property, also laws on the books to acquire land. Could be from land developers, corporations, the county, the state, whoever, for use of benefit of the people, use of eminent domain, or whatever you want to call it. But yeah, I think it's a very good video, decent video, basic video to get people starting to know what's their property, who are heirs, and what are the tools, legal tools that is, or even some of the business vehicles, or trusts, or legal vehicles such as a land trust or trust of the property under, to consolidate ownership, consolidate how property is going to be utilized and managed. If you want to put in an LLC, they talked about it, how the heirs or owners of the property will put all the interest into the LLC, which will own the property, and in return, heirs owners of the property will own the LLC, so they will receive a profit with the profit, as well as they can have direct input as far as how the property will be managed and utilized through the LLC. So yeah, I just wanted to share this with you, give my thoughts on the matter, and thanks for tuning in, thanks for watching, and I'll see you in another video. All right, take care.